This is a break for me, actually. It's probably not a break for anyone else in the country to talk about this Justice Department, but I've actually spent the last week or so talking about a new book, as Roger mentioned, and I don't know how I wasn't able to orchestrate this sort of stuff when I was a prosecutor, believe me, but somehow, right as the book about the Arab Spring, so-called, came out, the Arab Spring myth started to explode, and my famous former defendant, the Blind Sheikh, was once again in the news. I kind of feel that this happens every 5 years or so. You know, he does something crazy, including issuing the fatwa that approved the 9/11 attacks from his American jail cell, as bin Laden credited after 9/11. But he does pop up this way from now and again, so I sort of feel like you know, I guess like the Rolling Stones have a farewell tour every 5 years or so, right? They're coming around for the last time, and I always think we've had it with the Blind Sheikh, and then he pops up yet again, and he has popped up in connection with the Justice Department, which I do want to spend a couple of minutes speaking about this morning. You know, you could, if you wanted to catalog everything that's been wrong with this Justice Department, you'd have to give me a lot longer than just a couple of minutes. I actually wrote a pamphlet for Encounter Books. I think it was in late 2009, early 2010, claiming that the Obama administration had pervasively politicized justice. That was, I think, less than a year into the administration. And the record at that time was already outrageous enough that it was worthy of at least a pamphlet, if not something more than that. That seems so bygone now with what we've seen in the last several years that it's almost, you almost can't remember it, even though it had the country pretty hopping mad at the time, particularly the effort to give Khalid Sheikh Mohammed, the mastermind of the 9/11 attacks, a trial in civilian court rather than a military commission. But the last 3 years have, as I said, just sort of made that seem almost hard to remember. That's how bad the record has been. And as a result, I think the best way to try to talk about the Justice Department from a sort of a 10,000 feet overview level is to try to do it thematically, because if we ticked it off scandal by scandal by scandal, we could be here till next week. So I want to hark back to the 2008 campaign, because it's important to remember what the role of the criminal justice system was, the federal justice system was in the campaign. If you remember, there were two big criticisms by the left. One was that the Bush administration had been a major departure from the rule of law, and the other was that the Bush administration had politicized justice. You remember that was the rationale for driving Attorney General Alberto Gonzales basically out of his position, the claim that the Justice Department had now begun to take political affiliations and political stands into its actual law enforcement decisions. And looking back at that campaign now, 4 years later, it just seems like what I thought at the time has been proved to be true, which is that if they're moving their lips, they're projecting. Because what we have seen in 4 years is just the most outrageous overrunning of both the rule of law and the most thoroughgoing politicization of law enforcement that you can imagine. Thematically, I think on the question of the rule of law, it's important when we talk about that to think about what the rule of law has to do with our society. In a free society, the idea behind the rule of law is the preservation of ordered liberty. In other words, we are a society that is controlled by our traditions and our culture, and the law is what we have, that protection that we have, that undergirds us, that allows us to conduct our affairs in a way that enables us to run or to have flourishing lives and flourishing businesses. The Obama administration's idea of the rule of law is a little bit different than that. Actually, it's drastically different from that. Their idea of the rule of law is to socialize the society. And I don't mean socialize in the sense of socialism. I'm not making an economic argument here. I'm making an argument that the law, in their view, is kind of the lasso that pulls the benighted society along in the direction that they want to take it in. And one of the things I think you need to understand about the ideologues who are in the Obama Justice Department, and they are legion, is that they absolutely believe in what they are doing. They don't think that they're doing anything corrupt. They are on a mission to bring the society in a certain direction, and they are using the levers of power in order to accomplish that mission. That's their essential idea of what the rule of law is. The law as a tool rather than a protection for our society. The other thing to bear in mind is politics and justice. We always say that we don't want the Justice Department to be politicized. We don't want law enforcement to be politicized. And that's right, but it's also important to remember that there's little in our domestic politics that's more important in terms of political accountability than how law enforcement is conducted. When we say we don't want the Justice Department to be politicized, we don't want law enforcement to be politicized, what we mean is political consideration should not have any bearing whatsoever on how individual cases are run. And that really is the way that most U.S. attorneys' offices work. I'm a pretty opinionated conservative. I was in the U.S. Attorney's Office in New York for almost 20 years. Most of my colleagues were left of center, as you would expect from reams of lawyers in New York. Some were not. Some were extremely on the left. I can't remember a single case in 20 years where that made any difference. Because if law enforcement is being done right, the only politicking that goes on, the only politics that is brought to bear on it, is the choice of what the enforcement priorities are going to be. So for example, the Bush administration prioritized national security, which made sense because that was the threat environment that we were in at the time. The Clinton administration prioritized other things like Medicare fraud and the like. So they would move resources out of things that the prior Reagan administration and the prior Bush administration had prioritized, and they had their own set of priorities. That's fine, but that's something that we need to be politically accountable about. So when we talk about politics and justice, that's the proper politics and justice. What we're seeing in this administration instead is not only an out-of-whack choice about what their priorities ought to be, but the actual use of political philosophy in deciding who gets prosecuted and how cases get conducted. And that, for somebody who's been inside the Justice Department, is an unbelievable thing. And for those who are outside the Justice Department watching, it's an intolerable thing. And it ought to be a reason why we take that into account when we vote in November. There can't be, if you have a situation where the Justice Department is using politics in the actual enforcement of the law, then you don't have a rule of law anymore. And you don't have equal protection under the law anymore. There's a number of cases. I know the Fast and Furious report just came out, and there are things that we could say about that. John Fund mentioned the Media Matters fiasco that came out in the last week. I'm proud to say that I'm one of the people who Media Matters apparently follows around. Hi guys, good to see you out there today. But I think particularly the Media Matters piece is small potatoes compared to what the more thoroughgoing issues that we need to discuss. Of course, it's outrageous that the Justice Department essentially has an outside group, Media Matters, that it is using as an adjunct of the press office to go after its critics. And I don't mean to be a babe in the woods. I don't mean to suggest that prosecutors never try to spin the media. You know, I was around a long time. I know that happens. But there's a difference here. Essentially, when the government talks, particularly in a law enforcement context, we should not speak until we're ready to speak in the courtroom. And all the speaking that gets done is supposed to be about cases that already have allegations made in them that are a matter of the public record. And in those instances, I think it's not only appropriate, it's often necessary for the government to speak publicly, because it's important for the public to understand what it is that the Justice Department is doing, particularly in cases that it's bringing in the government, in the public's name. And if those things are being misrepresented, whether by defense lawyers or by people who have them wrong in the media, it's important to correct that. But what the Justice Department is doing with Media Matters is not trying to spin matters that are about cases that are on the public record. What they're instead doing is trying to control the public debate. They're trying to control the court of public opinion, not what goes on in our own courts. And that is that's unacceptable, and it ought to be unacceptable to people. But I want to talk, in the couple of minutes I have, about 4 particular areas where I think the Justice Department has really undermined the bedrocks of our constitutional order, and what ought to be both frightening to people and ought to galvanize people in terms of the decisions that have to be made in the months ahead. Probably the most important thing is equal protection of the law. That is one of the bedrocks not only of our constitutional system, it's one of the things that the Justice Department is in place in order to safeguard. That's why we have civil rights laws. That's why we have a federal law enforcement role in the first place, to make sure that all of the citizens are treated equally and regarded equally before the courts of the United States. In the new Black Panther Party case, the outrageous parts of it are already well known. This was a very obvious voter intimidation case where the Justice Department actually had the case won. The defendants had defaulted. The judge was just waiting to enter judgment in favor of the United States. And the Holder Justice Department, evidently under pressure from interest groups, actually went in and pulled defeat out of the jaws of victory, actually dismissed the case even though the government already had the case won. That was pretty astounding to anybody who has been in the Justice Department or watched the Justice Department for any length of time, for them to be on the precipice of winning a case and pulling back. But what was more outrageous, and what really ought to upset people a lot more than that, is the fact that we learned from some of the whistleblowers that John Funn was talking about this morning, we learned that the Justice Department actually has a racially discriminatory philosophy in the enforcement of the civil rights laws. Now think about how perverse that is. The civil rights laws are the thing that are in place to guarantee the equality of citizens across the board. And the Justice Department, as a matter of philosophy, believes that if an offender is a minority group, particularly African American, and the victims of a civil rights violation are not members of a minority group, and particularly Caucasian, they do not believe civil rights charges should be brought in those cases. Now, there's utterly nothing in the statutes themselves that say that. As a matter of philosophy, however, this Justice Department takes the position that the civil rights statutes are sort of the province of African Americans and they can't be used against them at any time. That's just wrong. I mean, you can't have, it's not a Justice Department if you are enforcing the law in a way that creates multiple classes of citizens. And that's what this enforcement practice does. Then there's federalism. I think that's the second thing, states' rights. If the states cannot defend themselves, they're not sovereign anymore. And that's a pretty basic element that is really sort of essential to the foundation of our country. If it had been thought that the states were surrendering their sovereignty, there would not be a United States of America. In fact, we went along for almost a century without a Justice Department. And for most of that time, the Attorney General was seen to be a sort of a legal advisor to the President who did not have a wide-ranging role in law enforcement. The reason for that is when the debates over the Constitution were taking place and whether it was to be adopted, the assumption was, and the commitment was from the Federalists, that the internal matters of the security of the states would be controlled by the states, and they would continue to maintain their own law enforcement systems, and there wouldn't be a federal law enforcement role. So that's something that we began to part from about a century after the Constitution started. But what we're now seeing is something that's not only an evolution of that, but actually a complete reversal of the underlying assumptions that our country was based on. The Justice Department sued Arizona in the immigration case, notwithstanding the fact that Arizona was actually, the Arizona law that was at issue actually involved bolstering federal law enforcement. In other words, what the Arizona statute allowed the police and other law enforcement actors in Arizona to do was enforce the federal law as a kind of a backstop to the Justice Department. This was not a case where state law was actually colliding with federal law. They were actually totally in harmony, which is the sort of a case where what's called the preemption doctrine should have no role whatsoever, because there can only be preemption when the laws are actually colliding with each other. The Justice Department took the position that a state now not only has to be consistent with federal law, which would have been a shocking doctrine as far as the founders are concerned, but they now have to be consistent with federal policy, meaning to say executive branch policy. So, for example, if the immigration laws maintain one thing, but the executive branch says, well, we're not going to enforce the immigration laws, which they can do. Prosecutorial discretion has been part of our law from the beginning. If the president says, I'm not going to enforce the immigration laws, the states now are preempted even if their laws completely are harmonious with the federal laws. So basically they're being told now that they not only don't have the sovereign right to make laws that conflict with Congress, they actually, even if they do take that step, they no longer have sovereign power if the federal administration that's in power decides that it's not going to enforce the laws. And again, if the states if they cannot defend themselves, they're not sovereign. If they're not sovereign, then the agreement that was the basis for the adoption of the Constitution is no more. Security is the third thing. From the beginning, the administration has undermined the Bush approach to counterterrorism. During the 90s, we tried the approach of having counterterrorism mainly be a courtroom issue. And from the time the World Trade Center was bombed in 1993 up until the 9/11 attack, that 8-year period, we basically treated this as if it were a crime or a crime wave rather than a law and a war. And what ended up happening was we were repeatedly attacked, and the attacks got more serious over time. When the Bush administration came in, and especially after the 9/11 attacks, they decided that that approach was a failure, and that what we needed to do was treat a war like a war and invoke the laws of war. Now, the people who were now running the Obama administration, when they were academics and private lawyers who were criticizing the Bush administration during the Bush years, took the position that what Bush was trying to do was inconsistent with the rule of law. And in point of fact, the law of war, which allows us to detain enemy combatants until the conclusion of hostilities, and allows us to try by military commission, not in a civilian court, enemy combatants who commit war crimes, has been the law of the United States in wartime from the beginning. The aberration begins in about 2004 when the courts begin to get themselves involved in warfare and the handling of enemy prisoners, which is unprecedented in the history of the country. And as we've seen in the last 4 years, we've had almost no military commissions. We've had attempts to bring enemy combatants into New York and other jurisdictions, in other civilian jurisdictions in the country for trial. It is an undermining of our war footing. I have one other thing to say, and I got about a minute?
Yeah.
Free expression. This is a story that's gotten almost no coverage. It's mostly a State Department story, but it's important that you know about it. The administration has been working with the Organization of Islamic Cooperation since the very beginning, since 2009, on resolutions which are designed to impose over our First Amendment free expression rights the Sharia, the repressive Sharia standards of speech. So that began with the State Department joining with some Islamist governments, including Mubarak's Egypt back at the time. Egypt under Mubarak still had a Sharia constitution, even if Mubarak didn't bother with it himself too often. But the administration joined with Egypt and other Islamist governments in 2009 to propose a resolution that would call on states to use their power either to prosecute or make illegal speech which cast Islam in a bad light. They did it under the heading of defamation of religion. That's something that has picked up pace over the years to the point where in 2011 the United States actually hosted the OIC's conference on religious intolerance and tried to settle on a standard that would make it illegal not only to incite violence, which is, by the way, already a crime, you don't need a resolution for that, but also make it a crime, or at least make it illegal, not necessarily a criminal offense, speech that incited either discrimination or hostility to religion. And the obvious intent of this is to make any critical examination of Islam or Islamist ideology illegal, and at least to depress or discourage anybody who would engage in that. It leaves us defenseless in about every way that you can think of that's important, because it's not only what the laws say, there is the ethos that is created by the law. And we've been through this again and again in the Justice Department. We were through it in the 90s when we had the intelligence walls up where the criminal side of the house couldn't talk to the intelligence side of the house. What you eventually get is a sense throughout law enforcement that cooperation or communication is discouraged and nobody tells anybody anything, and the country is terribly vulnerable. It's happening again with speech. They're purging our intelligence files of, they say they're purging it of information that is defamatory of Islam. Back when I was a prosecutor in the 90s, we used to call it evidence. So it's obviously a different perspective. But they are creating a culture within the Justice Department that basically says, if you're looking for the ideology that animates the enemy, you're basically violating their view of the Constitution, which is a warped view of the Constitution. The important thing about it is you can't protect a country with blindfolds on, and you can't protect the country by ignoring the enemy's threat doctrine. I can't imagine anything that would make it more likely that we'd see terrorist attacks in America again. And on that happy note, I guess I should stop. We ought to be very concerned about it. I think not only because they're pushing something that is so obviously anti-constitutional, but let's face it, if President Obama is reelected, I think he's already appointed 200 judges. There'll be another couple of hundred judges, plus at least 1 or 2 Supreme Court appointments. And look, the judiciary, it doesn't matter that I can show you a jurisprudence a mountain high. that says that this violates the First Amendment, if they stack the judiciary with people who think like they do, and think that the First Amendment is elastic enough to embrace a Sharia repressive speech standard, that's the end of the First Amendment. Yes, sir.
Okay. So I read through the whole Sharia law on Wikipedia, and so I'd like you to perhaps comment on, I think, why would someone even want to allow this in the United States in any form whatsoever, since their stated goal is to have everyone under Sharia law?
Well, because nobody's interested in what their stated goal is. So this is sort of an incremental strategy, so that basically people who are sympathetic say, well, we don't have to take the jihad part of it, and the repression of women and religious minorities, and that death penalty for homosexuals, that's probably not going to fly here. But they say, these finance standards, they're okay, and after all, don't we want Muslims to be able to participate just like everybody else in our financial system? And of course, the answer to that is let them participate like everybody else in our financial system. Don't change our rules and our culture over it. But there's a blindness, I think, not only on the left, by the way. I think there's a blindness in general in the country to what the animating threat of this is, which is that it's a supremacist threat where they want to implement Sharia gradually with the idea that eventually it would be fully implemented. And that seems fantastical to us, but these are people who think that they defeated the Soviet Union, and there's two big old buildings in Lower Manhattan that aren't there anymore, that if you told somebody a couple of days before that happened that something like that could happen, they would have said you were crazy.
So one quick follow-up. Of course, what mystifies me about this is their objectives are very clearly stated. So how can all these highly educated elected officials be completely ignorant of their clearly stated goal for this?
Because they're evolving us, and they think they're evolving Islam too. So there are some people, I think, who get it and recognize that that this is that at least in the Muslim Middle East, the chance that the culture is going to change there anytime soon, and the really visceral anti-Americanism, anti-Westernism is going to change anytime soon, that will never happen. There are other people who will tell you in good faith, I think it's loopy, but they believe it, that if you allow these Islamists to take positions in government and they suddenly have responsibility for governance, that will tame them, because they'll realize that they're now politically accountable and they'll have to serve their constituencies, and it'll pressure them to moderate. And this is one of those theories in search of evidence. I mean, if you look around, whether it's in Iran or it's Hamas in Gaza, or just watch the Muslim Brotherhood in Egypt, and certainly look at what's happened in Turkey since Islamists have taken over, the societies that are democratic become progressively less democratic, and the societies that are authoritarian become totalitarian. So that's what the record is. And the fact is that in that culture, it's a different civilization. It's a different way of looking at the world. People's idea of freedom, I'll get into this more this afternoon, but people's idea of freedom is not the same idea that we have in this country about freedom. It's almost the opposite. So the thought that suddenly serving their constituents is going to moderate them is a farce.
One last one.
Yes, sir.
I understand the last point. Of course, it's frightening. I understand the last point, and it is frightening, of course. Can you be specific about, with an example or two, where there's been a conflict of Sharia versus normal law?
Sure.
And I think it could be appreciated more if you could give an example of what's happened and then how it would be.
In my own great state of New Jersey, we had a Muslim couple that was in court getting a divorce. The woman was seeking a divorce. I think they were from Algeria, if I'm remembering this correctly. She came into court seeking a protective order because she was being serially beaten and raped by her husband, who she was trying to divorce. And he told her, This is our religion. You have to do as I say, which is there is a solid interpretation. There is interpretation that goes the other way as well, but there is Islamic scholarship that holds to the proposition that there can't be marital rape in Islam because the woman must submit to the man's demands. When she went in and sought a protective order, which a woman in that instance would get in virtually any other case, the judge in New Jersey denied it because the judge held that in the man's mind, the husband's mind, or the soon-to-be ex-husband's mind, he wasn't doing anything wrong. He was simply honoring his own religious and cultural tradition, and therefore he lacked the intent to commit rape. And without rape having been committed, there wasn't any real basis to issue the protective order. Now, the fact of the matter is that case got reversed by the higher courts. But what the inside baseball that lawyers know that maybe the public doesn't always realize is there's very few cases get up to the appellate courts. And very few, even the cases that do get up to the appellate courts, there's very few claims that actually get resolved versus the claims that actually get raised in the trial court. So the point is, you know, the Center for Security Policy did a study on this. They found, without having to break into a sweat, about 50 cases where Sharia has come up in one form or another in all of the different states across the country. And what I'm saying is that their methodology was to look at reported cases. And I'm telling you that most of the cases in the United States are not reported. The day-to-day stuff that goes on in courts it usually never becomes an appellate case, and it never rises up. So we really don't know how much Sharia enforcement there is. We just know that there's more than there used to be.